Hi, my name is Russell Morgan. I'm the founder of the Morgan Legal Group, and today we're going to talk about the difference between a living will and a last will and testament. A lot of people come to me for a will, and unfortunately a lot of times they'll use the terms interchangeably. I need a living will, I need a last will, and today we're going to explain what is a living will and what is a last will and testament and why both are important. A living will, sometimes called an advance directive, is a legal document that provides instructions regarding the medical care a person wants to receive if he or she becomes incapacitated or seriously ill and can't communicate their preferences themselves to their doctors. The details of the living will often include considerations such as whether the person would like to have sustaining medical treatment or feeding and breathing tubes to be used. An attorney in fact or a healthcare proxy will be appointed in the advance directive to represent the interests of the living will's owner. Through the power of attorney, this agent communicates with the doctors and other medical personnel regarding the person's desires as expressed in the living will. Now, what is a last will and testament? A last will and testament, also known simply as a will, is a legal document that provides instructions for what should happen to a person's assets after his or her death. If a person dies without a will, they are said to be intestate, and state intestacy laws govern distribution of the property of the decedent. Now, note that it's possible to name a guardian for minor children, as well as a person to manage their financial affairs in a last will and testament. Quite simply, if you are a parent of a minor, you should have a will. The person drafting the will, called the testator, chooses an executor of his estate who will carry out the will's provisions through the probate process. The executor is responsible for gathering property, keeping financial records, and paying any outstanding debts and taxes after the decedent has passed. Now, these debts and assets are paid through the decedent's property. The differences between the living will and the last will and testament, other than the fact that the living will and the last will and testament serve different purposes, another major difference between the living will and the last will and testament is when they take effect. A last will and testament doesn't take effect until after the death of the decedent or the person who wrote the will, while the living will takes effect as soon as the person is incapacitated. Maybe you're wondering whether you need a last will and testament or a living will. Well, the answer is easy, because just about everybody should have both. Each offers you the peace of mind that your wishes will be followed when you can't make them known, either because of incapacitation or death. In the case of the last will and testament, having one can also make the probate process go more smoothly. And with a living will, it can provide guidance to your loved ones making difficult decisions during a trying time. When should you get a living will and a last will? That's another easy question for me to answer, because there's no time like the present. No one can predict the future, so the sooner you have your preferences recorded in a living will and a last will and testament, the better.